Thank you. Thank you for kind introduction. And good morning, everyone.
Good morning.
It's an honor for me to be here as a keynote speaker in the 15th Asli conference. I'd like to express my deepest respect to all the distinguished guests, renowned professors, and participants at this event. I also want to say hello to those two students who gave up their morning routine to be here. The theme of today's conference is Law into the Future. It's a very timely and important topic. As we approach the third decade of the 21st century, the legal profession is faced with a lot of unprecedented challenges due to technological advancements, particularly in the fields of the machine learning and biotechnology. And to mention just a few salient issues, many have emphasized the ethical issues arising from technological development, including challenges to the dignity and value of human life. Others have quotable legal measures to address the climate change and pollution, two of the biggest issues threatening humanity's very existence. Of equal importance is the issue of privacy within big data. The questions of how it could prevent governments and national corporations from exploiting sensitive individual information. I hope we leaders of the legal profession can continue to ponder these questions and many more in this conference. As a citizen of Korea, I think that the location of today's conference is very appropriate. As you see, the modern Korean lifestyle is very dynamic and fast-paced. Consequently, I feel the laws and legal systems should play a primary role in easing uncertainty, relieving pressure, and bringing stability to individuals whose daily lives are becoming very complex due to rapid changes. I also feel that law should ensure that individuals' rights are protected and their concerns and interests are protected, addressed equally and justly in the course of disruptive social, economic, and political developments in their communities. The key goals we should strive here are stability and predictability, replacing uncertainty whenever possible. In other words, our societies need to be governed by the rule of law. That's why I decided to name my lecture Revisiting the Rule of Law in Asia, again, from a Korean perspective. Rule of law is a very ancient concept and sound a mere cliche. But I firmly believe that it is still of primary importance, occupying a central place in how nations and communities should be governed and regulated. This speaks to every aspect of legal interpretation and enforcement. Thus, I believe there is a need to revisit the topic, the rule of law in Asia, utilizing some examples of theoretical problems involved in its definition and a few contemporary issues here in Korea that exemplify them. Over the past 20 years or so, this subject has been extensively discussed at various symposia and conferences held in Asia. Indeed, there has been a great deal of controversy about what the rule of law is. When you reflect upon the history of argument on it, you see that it has been pointed out the concept is very vague and abstract. On the other hand, I have found that narrowest definition is the one given long ago by Professor Dicey in the 19th century, who declared that the rule of law used to be a very proud tradition of governance in England from the so-called civil law systems in Europe. Perhaps it may sound attractive, but I believe there are few who would accept this version today. However, the three pillars of Dicey's definition, the absolute supremacy of law as opposed to the arbitrary power, and the equality before the law, and the independence of the courts that secure the individual's rights, are still being accepted as core universal elements of the rule of law. Many scholars agree that rule of law is one of the most crucial ideas of our political morality, and it refers to the ascendancy of law and of institutions of the legal systems involved in governance. Some legal philosophers further insist, as a matter of analytic clarity, that it must be distinguished from our conceptions of democracy, human rights, and social justice. They confine its focus to formal and procedural aspects of the rule of law, without regard to the content of the policies they implement. But you find that this point is somewhat controversial. Even the formal or procedural line of thinkers do not deny that there are the values underlying the rule of law that could help close the gap between positive law on one hand and our values of morality and justice on the other. Even in academia, it seems that some more substantive accounts are gaining momentum these days, resulting in the integration of the rule of law with other foundational values of liberal political systems. As a judge, I'm not in a position to join the fray over this controversy. Instead, I would just be content to quote this 2011 passage from the former Chief Justice of South Africa regarding apartheid. Quote, "Without substantive content, there would be no answer to the criticism sometimes voiced that the rule of law is an empty vessel into which every law can be poured." End quote. When I survey the literature on this topic these days, among the recent literature on the rule of law in Asia, what attracts my attention is there are many articles which emphasize the positive effects the rule of law can generate, such as sustainable economic development and facilitation of trade and so on. It seems to me those views focus on the procedural aspect of the rule of law, and that this view does indeed assist to promote the rule of law in this region. Recently, the literature on the rule of law and economic growth has become one of the more dynamic areas of theoretical and empirical work in political science, economics, and legal theory. However, some scholars are critical of this view because it has been found that correlation among different components of the rule of law are not tight among developing countries, and that some inferences about the effects of property rights protection on economic development may not be warranted. I would also like to note that even today, some scholars argue that the confidence in benevolence of the so-called enlightened rulers in Asia should not be ignored in context of the Asian values, our traditions. They point out that establishing the rule by law itself is more urgent, considering that the violence and corruption can threaten the stability of the government itself. It's true that rule of law can never be separate from the people who make up our government and our institutions, although it is more of an ideal we should always strive for, but fail to live up to. At present, however, despite the different situations and environments of the countries across the region, I believe that the rule of law is being accepted as a universal principle, as well as an indispensable mechanism for upholding democracy among peoples and countries in this region. It now seems that now the focus is shifting to develop institutions and procedures to try to make the rule of law a working reality. On that note, I would like to take a moment to remind all of us of a passage in the preamble of the Universal Declaration of Human Rights of 1948. Quote, "Wherever it is essential, if man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, the human rights should be protected by the rule of law, end quote. That said, I would like to move on to talk about some issues related to the rule of law in Korea, and particular cases that might serve as illustrative examples. First, if the rule of law as a constitutional principle aims to protect human rights and to uphold democracy in matters that the separation of powers and judicial review, should be able to constrain unauthorized actions by those in power. Regarding judicial review, the relationship between the Supreme Court and the Constitutional Court has always been a thorny issue here. This area of our Constitution was last amended in 1987 as a result of the successful democracy movements in the mid-1980s. Paragraph 1 of Article 101 of the Constitution provides that judicial power shall be vested in courts composed of judges. And paragraph 2 provides that the court shall be composed of the Supreme Court, which is the highest court of the nation, and the other courts at specified levels. Yet it later includes separate provisions on the establishment of the Constitutional Court in Chapter 6 and the National Election Commission in Chapter 7. The Constitutional Court is granted exclusive jurisdiction over such matters as ruling about the constitutionality of statutes upon the request of the court, impeachment, and dissolution of the political parties. Although whether the Constitutional Court is one of the institutions of the judiciary or a special tribunal established by the Constitution is frequently still discussed in academia. The Constitutional Court cannot interfere with the judgments of the court. The Constitutional Court has been very active in declaring significant numbers of provisions of statutes implemented under previous authoritative governments as unconstitutional. Those efforts contributed to the democratization of this country, as well as the protection of civil and human rights in many sectors of the society. The recent decision of the Constitutional Court on the impeachment of the former president of this country, improving her from office, certainly marks as a milestone of a modern history of Korea. Meanwhile, the Supreme Court, as the highest court, has ultimate judicial authority to interpret statutes, as well as the final authority to review administrative acts, including review of secondary legislation. It is true that there exist tensions and conflicts surrounding the Constitutional Court authority to decide on the constitutionality of statutes and the Supreme Court power to interpret statutes so as to be consistent with the Constitution. As a matter of fact, both powers may be inseparable because they are two sides of the same coin. Therefore, I believe that it would be desirable for the Constitutional Court to not decide on the constitutionality of a statute based on the abstention doctrine until the Supreme Court clarifies the meaning of the statutory provision at issue. It's not uncommon, though, that the Constitutional Court renders its rulings based on its own statutory interpretation, and these opinions are deemed as just advisory opinions by the Supreme Court. This is precisely the reason that the need for consolidation of the top two courts is being raised whenever discussions are sparked on further amendment to the Constitution. If a consolidated court retains existing authorities of both courts were to be established, then this might generate serious concerns over the so-called politicization of the judiciary, or the judiciary might become a super branch of government, inappropriately superior to other branches. Criticisms may as well follow that granting excessive power to judicial officers who are not elected by the people undermines the legitimacy of the entire system. That's where we stand now. The second issue involves the rule of law on the international level. These days, here in Korea, applying international human rights laws to our domestic court draws a high degree of public attention, particularly with regard to the application of the International Covenant on Civil and Political Rights that was adopted by the UN General Assembly in 1976. In November of 2006, in the Union versus Korea case and the Choi Myung-jin versus Korea case, the United Nations Human Rights Committee declared that the conscientious objection to military service warranted protection under Article 18 of the Covenant on the grounds that it constituted an expression of religious or ethical beliefs. However, a year later, the Supreme Court determined that a religious conscientious objection to military service did not constitute justifiable grounds as defined under Article 88 of the Military Service Act, inasmuch as Article 18 of the Covenant did not expressly specify the right of conscientious objection as a fundamental human right. Additionally, in 2011, the Constitutional Court rendered the ruling that the provision of the Military Service Act regarding the punishment of conscientious objectors was not unconstitutional. However, in 2005, the National Human Rights Commission already had affirmed that the rights of conscientious objection fell within the ambit of freedom of conscience under Article 19 of the Constitution and Article 18 of the International Covenant on Civil and Political Rights. Accordingly, the Commission recommended the introduction of a so-called substitutional services system for conscientious military service objectors. The Korean government announced the introduction of its plan in 2007, and the bill for the revision of the Military Service Act was submitted to the National Assembly in 2011. It followed similar international precedents. Taiwan had already enacted legislation for an alternative service system in 2000, and in 2011, the European Human Rights Court determined that conscientious objection to military service warranted protection under Article 9 of the European Convention on Human Rights in the Batayan versus Armenia case, changing its form of view. However, the Korean plan came to naught due to strong public sentiment that it was too early to adopt a substitutional service system when bearing in mind the military standoff between two Koreas and the need to protect our national security. Public opinion remains divided over recognizing the right of conscientious objection. We take up this crucial issue and resolve the controversy. It be the Supreme Court, or the Constitutional Court, or the National Assembly. Thinking of recent summit meeting between two Koreas, and if they succeed in replacing the current so-called truce regime with an effective peace regime and an official resolution of Korean war, we restore the public sentiment to the advantage of the conscientious objectors. This is a question waiting to become answered here. Thirdly, despite widespread societal efforts toward promoting and protecting human rights, courts are always on the receiving end of criticism for having neglected to protect the rights and interests of sexual orientation and gender minorities, migrant workers, and victims of sexual harassment and sexual assault. In particular, the Supreme Court has been strongly criticized for not being able to break away from conventional views and Korea's male-dominated culture. Against such background, in the 2006 case pertaining to the request for name change and family register correction, the Supreme Court held that transgender people should be able to legally change their gender consistent with their gender identity in view of Article 10 of the Constitution. That ruling caused quite a stir in this country at that time. Furthermore, calls are growing in Korea for same-sex marriages to be legalized in line with the recent US Supreme Court decision that legalized them, followed by Taiwan becoming the first Asian country to officially permit them. Law courts in Korea have rendered rulings that rejected the legalization of same-sex marriage, but those cases have yet to be appealed to the Supreme Court. In 2015, the Supreme Court rendered an en banc decision over a case involving undocumented migrant workers' right to form trade unions. The majority opinion determined that such migrant workers were entitled to form trade unions regardless of their visa status, because those workers can be included in the scope of workers under the Trade Union and Labor Relations Adjustment Act. The recent sexual harassment scandals and the Me Too movement have shed light on the need for stronger measures to protect the rights of sexual harassment and sexual assault victims. In the recent judgment on April 12, 2018, the Supreme Court determined that a victim's testimony should not be rejected. The court based its rationale on the so-called secondary victimization and gender sensitivity. It emphasized that sexual harassment cases ought to be resolved with greater gender sensitivity. My observation is that aforementioned recent decisions of the Supreme Court reflect its overall efforts to expand the rule of law in this country. But I admit that they might still fall short of the expectations of the general public. On a broader note, I claim that the importance of the rule of law cannot be overemphasized across the Asian regions. There may be setbacks and frustrations in the course of pursuing our common goals of establishing the rule of law to enhance the quality of life, safeguard human rights, and build a just society for ourselves and our next generations. However, we cannot be content with the status quo. There is simply too much at stake. In closing, I sincerely hope that our discussions in this conference today on the rule of law will act as a platform for exploring various issues related to this year's theme, Law into the Future. Thank you. Thank you.